Good evening and a very warm welcome to one and all our participants and fellow IPs. On behalf of IPNet West Region, I would like to extend a warm welcome to all of you to today's webinar, which is titled Challenges Under the Personal Bankruptcy Process. We are truly honored to have with us our distinguished keynote speaker, Dr. Nipun Singhvi, and our, I want to say guest speaker, our very much own speaker, Dr. Ashish Makhija, sir. As you're aware, IPNet is hosting its 55th webinar in the series of webinars organized periodically under the umbrella of IPNet, which is the National Network for Insolvency Professionals. Now, without further much ado, it is my pleasure to invite Mr. Udairaj Patwardhan, sir, member of the National Executive Committee and Regional Head of IPNet West, to deliver the formal welcome address. Sir.
Thank you, Namrata. I am really glad to welcome you all for this 55th webinar on challenges under personal insolvency process. We will, of course, be guided by Dr. Ashish Makhija. Soon he will join us. However, the person to look forward to is a wonderful speaker and a friend of mine, Dr. Nipun Singhvi. And the topic he will be tackling, as we discussed, is challenges under the personal insolvency and bankruptcy process. So this IPNet has been there for more than 1 year now. And we are really thankful to Dr. Ashish Makhija for being the guide and the torch bearer for this movement that we are doing. We have been able to support IPs through expert-led learning initiatives, practical guidance on IPC-related challenges, and dedicated member portal. We always strive to take up the recent burning issues, challenging issues that our members face, and we try to address that in our weekly webinars that we hold. So today, on behalf of IPNet West, I welcome you all again, and back to Namrata for the proceedings.
I will just now play the video of IPNet and the website.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Thank you. Before we proceed, I will have to make an appeal to you to join our first physical national enclave that we are going to have at New Delhi on 1st of November at India Habitat Center. We are going to have the top of the game speakers who are experts in the field. And believe me, you will be witnessing the best of the speakers, best of the topics, and best of the panel discussions that you would come across in any webinar. We will be having various topics like out of court insolvency mechanisms, strengthening CRP through progressive judicial interpretations, balancing stakeholders' interest, typically between home buyers, MSMEs, and FCs, evolving importance of IPEs, their interrelationships, and their accountability and empowerment. And of course, we will be honoring the team members of our own IPNet fraternity, which have been striving hard with us throughout the process. We have early bird benefit till today, and please ensure that you register early, book your tickets early, and be there in large numbers. This will be an unique opportunity to meet all of us together at New Delhi at the IBC Conclave on 1st of November 2025 on a Saturday. Thank you. Over to you, Namrata.
Yes, sir. So now we can start our seminar for the day. I request Mr. Vikas Jain to kindly introduce our speaker keynote address by Dr. Nipun Sanghi.
Thank you very much, Namrataji and IPNet, for offering me this opportunity to introduce my dear friend Nipun Bhai. Nipun Bhai, to introduce Nipun Bhai is very difficult task for me, I would say, because the time that is there for introduction would be too less, and I know him for almost more than 2 decades now. We have been friends since then. So I know a lot of things which are not written in the uh, paper that has been given to me, I would say. And Nipun Bhai, he's a CA, he's a CS, he's LLB, LLM. Now he has also added the prefix of doctor with him from the Washington University. Besides this, he has been a regular speaker at various forums. And since 2016, when this IBC code came, when I was the chairman of Ahmedabad branch, since then he has been delivering a lot of lectures. I would say he's one of the first one who has been started delivering lectures so far as our area is concerned. He has delivered lectures at ICAI, ICSI, IIMs, and NLUs, and various trainings to the government officials, and all these things. His various cases have been reported. He has been regularly going to High Court, Supreme Court, tribunals, and whatnot. So, a lot of things that I can say about him. He has also been author of quite a few books on RERA, IBC, and so on. So, I'll not take much of that time, but straight away I would say that I can speak a lot about Nipun Bhai. He's a great speaker and great friend. Whenever we need any advice, we can always give him a call. He's just a call away. So, with this brief introduction, I would hand it over to Namrataji. Thank you. Thank you very much once again. And thank you, Uday sir.
So now the stage is all set. Thank you, Vikas sir. Nipun sir, the stage is all yours. We're all awaiting.
Thank you so much. First, IPNet, Uday Bhai, Vikas Bhai. Not only we all are friends, but all dear friends. I won't say that they are my clients also, because more than clients, they are also my friends. And as Vikasji rightly pointed out, for last almost 2 decades, Vikas Bhai and me have been taking sessions on corporate law together. In fact, when IBC was not there, from that time we have been taking sessions together. And Vikas Bhai was, I suppose, one of the few IPs who had registered for IP from Ahmedabad. And at that point of time, I told him that, sir, this is a very good law. You kindly start practicing in this. Because I was also assisting the Joint Parliamentary Committee in 2015. I never thought that it will come so soon in 2016. We never thought. In fact, when in June 16, the NCLTs were there because of Madras Bar Association, we thought that it won't come into force. So let's see how it has spanned over. But thank you very much, IP9, and especially Namrata ji for following up. And I apologize that for such short duration, I was not able to do my complete preparation. I have tried to justify my topic by including some of my experiences. And in fact, this particular area, I would say individual insolvency and bankruptcy, it's an evolving topic because we all are learning every day, and there are so many complexity in case of an individuals which we never envisaged during the company insolvency process. And even today I would say that the law is very silent on most of the aspects. Company side it has evolved too much, but in case of individuals much is to be done. I think I can just share my presentation. Ma'am, you will have to enable me, I think. Namrata ji,
Yes, I've informed the transition team to make you host, sir.
okay. So then I can just share the presentation. I will just flip through the presentation, some issues which I have come across, some solutions probable which I have got, and then what is the jurisprudence which is developing, and then some food for thought for everybody. What could be the possible solutions? Because I think the IPNet community is handling much more cases than individually I would have advised. But I think it would be a two-way discussion on all these things. In fact, Makhija sir is also going to join in the next session. So I hope to deliberate with him also some points.
So you can share your PPT with me till then. I'm trying to get in touch with the technical team.
Okay.
Yes,
So
I'll just
once
screen.
you confirm, then I will just share. But before that, I will just start speaking on my first slide of the PPT. And I think this is very important and very ticklish issue which we are facing nowadays. I don't know how this issue is being tackled by other IPs, but as of now, what I have been facing is once an, let's say, Mr. X is the PG whose insolvency is to be triggered, and he is also a guarantor in more than one company. Let's say A, B, C. There are three different companies. He is guarantor to all those three. And insolvency triggers in any one of them. So other companies also insolvency now cannot be triggered, and everything will get culminated in the insolvency of Mr. X. That's how the process begins. Let's say RP has been appointed for that particular individual. Now, what is the duty of the RP? Are there any duties of the RP in PG chapter of the insolvency enumerated? I could not find any specific duties and rights, just like we have duties and rights in case of CIRP. If you see, we have section 18 there, we have section 25 there, we have clarity like we have to take control and custody of the assets of the corporate debtor. So there is no such specific guidance, I would say, in case of individual insolvency. So I'm right now talking about insolvency, not bankruptcy, because in insolvency process, it is silent. When we will come to bankruptcy, it says that the assets of the bank, this PG, would vest in the bankruptcy trustee. So those assets will automatically get invested with the BT. Now the problem in case of insolvency process, that is the stage one of the PG, is there is no specific provision for control and custody.
So
So
you
now the
can share the
silence.
screen.
Okay.
Sorry. Yes.
I hope my PPT is visible to everyone.
Yes, sir.
In my example, if you can see, the individual personal guarantor is Mr. X. Now, he could be also a member or a karta of an HUF. He could be also a director in private limited company. He could also be a partner in a partnership firm. He could also be there as a proprietor. He could be there as a trustee. He could also be a director in a listed company. Now, and I want some interaction and answers, whatever is possible from all the participants. How do you deal with a situation? Let's say he's a director in a company and his insolvency is triggered. Can he continue to be the director of the company? Anyone, any participant, please volunteer so that we can have an interactive session.
Uh, Mukul bhai, may I?
Yes, Hemanji, please, please.
Yeah. See, I am just sharing my experience. I don't know exactly what exactly to be done, but anyhow, it's only just whatever the practical situations are there, how to face it. That is the only. See, normally we take a search from the ROC where they are involved as a director or they are partners in the LLP, or if the records are available from the personal guarantor that they are partner of XYZ private partnership firm or HUF and everything. We just try to give a notices to all these entities like trust if they are trustee in the trust, and then we just inform them if you have any claim or such things, you can put it before or information available to you as regard to this particular case. You can share it with us. That's the only thing which we can do, because we have to call the resolution plan. And in fact, I can say the repayment plan from this person. So right now, there is no any coercive action or nothing is to be done from our side, except just informing to those entities. And if those entities also have certain dues, they will just note down their dues towards that particular person. So that is the only, I think, limited things which are available as an RP. With due respect to the audience, there are many IPs who are more than experienced than me, so they can also share their views.
Great. So my question was whether that particular person would be able to continue as a director in any company or not. So let's say the company for which insolvency has initiated, it is ABC Private Limited. Now in ABC Private Limited, obviously he will not be there. But whether other companies, let's say ABC1, ABC2, ABC3, other companies, can he be there or not? Now you see, interestingly, once a person is under insolvency, you see section 164 of the Companies Act. What it says? It says a person shall not be eligible for appointment as a director of a company if he is an undischarged insolvent, he has applied to be adjudicated as an insolvent and his application is pending. Both the cases he will not be eligible for appointment as a director. Now, there are various judicial precedents where the appointment has been interpreted that it will not only apply to appointment but also for the continuation of being a director. So if you interpret both of this together, it means that person will not be able to continue as a directorship in other companies. This is a very tricky situation once that company is under, because hit by disqualification. I have got one case where there were two directors, husband and wife. Both of them were also declared as, I would say, insolvency triggered. Now, because of the admission order of insolvency, their all other entities also become headless. I would say headless. According to me, and again, this is my own interpretation, the matter is pending before courts. Whether that particular RP will now take the control of that B company or C company or whatever other companies are there, qua which insolvency has not been started, because debt qua a company will only get admitted in normal circumstances. It is possible that other companies are healthy. It is also possible that other companies are also defaulted or maybe NPA. But the question only here was whether that particular person can continue to be director in another company. So my view is that it cannot be. And because the RP is having the right of being appointed as a court officer for all legal purposes, he would have to now take control of the company. Now, again, if you ask me where is the provision, where is the rule, where is the regulation, it is not covered in clear words anywhere. Now, let us assume this case in case of bankruptcy. There is no quarrel in case of bankruptcy that all the assets will vest with the BT. As such, there is no quarrel. There cannot be a second opinion because the law is very clear. Now, in case of bankruptcy, how the control of the company will come? See, ultimately, company will have shareholders. Let's say in my example, these two are the shareholders. These two shareholders will have shares, which is ultimately asset, and then asset will vest with the RP or legally BT, bankruptcy trustee, and that bankruptcy trustee will then obviously have to take control of the. Now it is going to be another challenge while accepting the cases of PGs in such matters, how much toil as a BT or as an RP you will have to do to find out how many entities a particular individual is exposed to. Coming back to my slide, if you see only private limited company is not the case. It could be a partnership firm, it could be a HUF, it could be a trust. Now, in HUF also, he cannot continue as a karta, a person who has been insolvent. Why? Any idea why a person cannot continue to act as a karta in HUF? Yes, participants, your views, please.
He is acting as a trustee. So if he is the trustee himself is not, that is what my.
Okay. He's acting in the capacity of trustee when he's a karta of HUF. Any other suggestion? Any other observation? What do you think, participants?
He is heading the HUF. So when the head himself is disqualified, and then the entity becomes null and void or invalid, etc.
Sir, he has become disqualified for the purpose of Companies Act only. I only talked about Companies Act.
I think,
interpret it in the same manner for HUF also?
I think since he's being declared as insolvent, he cannot enter or bind the HUF into a contract. So these binding powers to enter into a contract are restricted. That is the reason he cannot act as a karta. He may still be a member of that HUF, and his share is still liable. Whatever share that can be, taken away, but he cannot act as a karta of the HUF. This is my.
Okay. So basically, if we talk about HUF, it's a legal fiction entity. For the purpose of income tax, we all have PAN cards. We create HUF to get some tax benefit. Also, there is a concept of different school of thoughts. We have that Mitakshara, Daya Bhaga and all. Now, the person who is Karta, he is just like a manager. He is managing the assets of the HUF. Can HUF take a loan? Yes. Yes. I think KDIG was attempting to reply.
Yes. HUF can take a loan, so that is acceptable.
When the PRP started, so it can be deemed as a insolvent person has become insolvent? No, then only when the bankruptcy started.
Okay, so KDIG is pointing out to another angle whether admission order under section 100 can be treated as adjudicated insolvent or a pending insolvency adjudication. Okay, I will come on to that aspect also. I will share my views. But first of all, let us understand whether that person who is right now Karta of HUF can continue to be Karta of the HUF or not. Now, if you see the school of thoughts, it always says senior male member, some school of thought senior female member, and then so on and so forth, how the religious practices of a particular area is there. If you read Indian Contract Act, do you remember something? We used to read Indian Contract Act, I think, first year of our all graduation and our chartered accountancy course, we used to read Indian Contract Act. Section 11. Very jokingly, when we used to read that Indian Contract Act at that point of time, we used to say you are Section 11. Any idea what was Section 11? Uday bhai, Section 11. It has that idiot, lunatic.
Section 11 is competency to contract, basically.
Correct. So Section 11 has that who is not qualified. who is not
He is not
eligible.
competent to contract, yes.
Correct.
The five
So that,
reasons that are given, one of that is insolvent.
yes, one is an idiot also, one is lunatic, who is mentally unstable, and then it is also insolvent. So if
Yes.
somebody is an insolvent, he cannot do any contract. So forget about HUF. He cannot even contract. So the point I was trying to make is that once an insolvency is triggered, for all practical purposes and contractual purposes, that person will not be able to do any contract. If a person is declared bankrupt, can he enter into a contract?
Of course not.
Because I have clarified on insolvency part. Now I am talking about bankruptcy. So if you read section 141 of IBC, that's very important section because nowadays this issue is coming in every bankruptcy. I'll just read it out because I have not captured it in my slides. A bankrupt from the bankruptcy commencement date shall, clause D, prior to entering into any financial or commercial transaction of such value as may be prescribed, either individually or jointly, inform all the parties involved in such transaction that is undergoing a bankruptcy process. They prescribe it also. They prescribe not more than 1 lakh rupees of transactions can be done by the bankrupt. And this is something which is a hard hitting clause. So you basically become father of a bankrupt. He has to always come before you and ask whether I can enter into a commercial transaction or not. And that is something very, very difficult. I don't know how it will be administered, but this is very important that he cannot do any contractual transactions specifically of commercial nature. So this is again my thought. Now, whether a person, so I just see Mr. X is also a partner in a partnership firm. In that partnership firm, there are more than one partner. Again, one person has been declared as insolvent. Whether that partnership firm would continue or not. Your thoughts, whether it will continue or not? Yes, participants.
If there are two partners, one become insolvent, then the partnership deed will automatically dissolve.
Partnership will dissolve. Okay. Let's say there are three partners. One is becoming insolvent. Whether two can continue, one will exit. That's fine. One can exit or probably the firm can be dissolved. What will happen to the assets of that particular partner? Suppose there are two partners, both of them are PGs, both of them are under insolvency, and you are under that insolvency process, not bankruptcy process. Whether as an RP, whether we will have to take the charge and the control of partnership firms' assets or not. That is
Insolvency, it is not required. Insolvency, because we are not taking control over the assets of the
great. So now we have section 34 on screen. Where a partner in a firm is adjudicated and insolvent, he ceases to be a partner on the date on which the order of adjudication is made. So once the section 100 order is there, he is no longer going to continue as a partner, whether or not the firm is dissolved or not. So that means automatically he goes out. Can't continue.
Yeah, but I have a query here, Nipun sir.
Just let me read
the word insolvent, the word insolvent that is used in Partnership Act would typically mean bankrupt. That confusion or the issue lies across many laws that they have used the word insolvent referring to the Provincial Insolvency Act at that point. And that kind of insolvency in today's IBC we call bankruptcy and not insolvency. So that issue of the words used will remain. So I will humbly differ that when he is insolvent under IBC, would not necessarily retiring, but bankrupt, yes, it will retire.
So suppose, let us assume what you are saying, sir. Let us assume for a situation that a person is insolvent under IBC Now this Indian Partnership Act is not amended.
It is
Now we
not
have to
amended.
interpret such this clause 1, whether we should interpret only it in the situation of bankruptcy or whether under insolvency also it will trigger. Because the question today would be with the RPs that whether I can ask the PG to give me control of the partnership firm or not, or give me the accounts of the partnership firm or not, because ultimately he will have to sit, work out whether there is an asset in the partnership firm or not. Because the Partnership Act says partnership firm and partners for all legal purposes, they are one and the same thing because they are jointly and severally liable. We are not discussing the LLP. We are only discussing the partnership firm under the old Act, 1932. So the problem which is coming nowadays is that under insolvency, you cannot permit that particular PG to continue his business under the partnership firm. It has to be immediately stopped. Otherwise, new charges, new third party rights can be created on the assets of that individual. Ultimately, that individual will have some asset. So, a partner will have assets in the partnership firm until that assets are maybe calculated, adjudicated, dissolved, and that asset comes into the, I would use the word hodgepodge of the estate during the insolvency. It cannot be allowed to be free with the PG. So my view is that once the moratorium, I am talking about the final moratorium, not the interim one, once the moratorium kicks in, it has to be, the partnership firm has to be dissolved if both the partners are insolvent. Obviously, one of them is insolvent, other is not, or others are not. The firm can continue, but the date will have to be freezed and the accounts will have to be made for that particular individual PG. And ultimately, if there is a claim by the firm, it will have to come to the RP. If it is not a claim by the firm, then probably an asset from the firm might come in, because a payout could be there or a pay-in can be there. Both are possible in case of a partnership firm. This is again my view. These are all evolving things, and the matter which I was referring to, it is sub judice before NCLT with regard to this only, whether the partnership firm assets will come to the RP or not, and all sorts of arguments are being made. Some of them which we have discussed are also made by the other side. I am for the PG.
Is it from the date? Is it from the effective date of Section 100? It is admission only, no?
Correct, sir. So Section 100 says that the person is insolvent. Now he can bail himself out by bringing a repayment plan. So my view is that the date when the admission order is passed, these all firms, all companies, everywhere he would be disqualified or not eligible to continue.
But NCA adjudicating authority declares him bankrupt under Section 126 when
So
all the.
I'm not talking about the bankruptcy as of now. I'm just talking about the insolvency. See, in bankruptcy, the law is very clear. Everything vests with the BT. So in that case, whatever the
insolvency and bankruptcy is, I think, interchangeably used, what I feel.
I again have a humble submission.
Was very right when he said that the words used in other laws are pertaining to when it was presidency and provincial insolvency regime. Today it is IBC regime. But the problem is respective amendments have not come. So we will always take a restrictive interpretation. We will not be able to take a liberal interpretation because as an RP, tomorrow something he does in the firm and the other side files a case, he says, you cannot sue me, I'm enjoying the moratorium, then it is again going to be a difficulty. Because nowadays, I will tell you what is happening in the market, that every PG, to protect his partnership firm assets, to protect his other company asset, he is filing Section 94. Because moratorium is on. Once the moratorium is on, any legal action qua debt cannot be done. So whether it is filed or it is a fresh filing, nothing can be continued against the PG. So that interpretation is very wide. Yes, Uday sir, you were saying something.
Yes, I have a just query that the wording of Section 42 of the Partnership Act Section 42, subsection D is by the adjudication of a partner as an insolvent. So the word adjudication is used there in the code, in the act. So when a person is insolvent, as per IBC, there is no adjudication at that point. So that will also remain to be decided because the court doesn't give an order that Mr. A is adjudicated as insolvent. That kind of an order never comes. So I'm just pointing out certain issues which come to my mind.
So, sir, what do you interpret or take it from Section 100 order? What do you consider that PG? He's under insolvency but not insolvent. Can I take it like this?
Yes, that is how I would say because the
So then a person will
insolvency.
never become insolvent, sir. Then after this repayment plan doesn't come, then you have to proceed for bankruptcy. So that person never becomes insolvent technically, if we go by the words. So it's according to me, I would take a restrictive interpretation and make it insolvent. And I think Makija sir is also here. He will add something to this session. Maybe in his session, I can just run on to the next query. Then let us deliberate on this issue. I think this is something which everybody is aware. Talking about the excluded assets, I think everybody is aware what is excluded asset, but it is, according to me, not very much clear with regard to this tools, with regard to books, with regard to vehicles. In fact, one case which I came across, and State Bank was their creditor. They said just before insolvency, that person purchased life insurance policies, complete money which he had, the cash in hand or bank balance, whatever you say, he completely purchased it in the form of life insurance policy. Now this says it's unencumbered, it's excluded, and there is no cap. So it's again a very tricky situation. What will happen? Whether it will come under PUFE or not, that's again $1 million question, because again we have that PUFE provision in the second chapter, not the first chapter. So this is a tricky situation with regard to excluded asset. Also with regard to this purpose of employment, business or vocation, it's very unclear because this particular unencumbered tools, books, vehicles, it's not very clear from any law what would we partake the character of. In fact, if we compare it, this excluded asset, and I think some of the IPs are lawyers also, in SARFAESI also we have similar provision where there is an exclusion. Also, the similar provision is there in CPC, some assets which can never be attached. There is no such perimeteria exclusions provided in IBs. So this is again going to be a challenge in the court. One of the matters we are also there arguing this particular point, because if you see that, I think section 20 of CPC or 2, which says that what is excluded asset, similar to SARFAESI also they have excluded asset. We had that agricultural land also issue, that whether agricultural land can be attached or not. Then Supreme Court settled it in Blue Ocean Hotels matter, that under SARFAESI you can sell that particular asset also. But now under personal laws, under CPC, under SARFAESI, we have exclusion, a list of exclusion. I'll just show you what is the list of exclusion. But that similar exclusion is not given here. So this is again going to be a tricky situation, what is to be excluded. Now, what has to be excluded will not be counted for the purpose of assessment at the level of insolvency process with regard to repayment plan. So whenever we are talking about repayment plan, we normally see what is the assets available, what is the probable value of the assets, and whether that valuation of probable assets, somebody is ready to give a repayment plan. Because if somebody wants to bail out the PG, the repayment plan value will have to be somewhere around the assets which otherwise would become part of the bankruptcy estate. And that's again my personal view that this is the working of insolvency process. I'll come on to the discharge question. What is the difference between discharge if you do it under insolvency process and discharge if you do under bankruptcy? So there's a huge difference. Some of the issues which are coming, and I think these are very interesting issues. In fact, I think there was a half-page news on this particular aspect. Unencumbered single dwelling unit is an excluded asset with regard to rural and urban areas, with regard to 1 PG. And we have a very small amount, 10 lakh or 20 lakh. So normally the issue comes that if the value of the property is more than this, how it will be considered or how it will be asset. Now, the question which is now arising is, in olden times, I would say Sarfazi law times or RDTB law times, if there is a dispute between husband and wife, husband is the guarantor and wife files a case under domestic violence or asks for a share in the property, and the civil court gives her property rights. Maybe they generally give a standard order. I don't know, it is a practice different from states to states, but normally it is like one room is given to wife to stay with the children. Now that particular order, whether it will be getting interdicted by this IBC, again, this is a very big challenge because it was considered that whenever there are such orders in favor of wife from the property of the husband or probably maternal or whatever, they will not be allowed to sell that particular portion because it's a court order. Now, when such rights are already created in the property, how the auction will happen from the perspective of RP or bankruptcy trustee? Because RP will have to assess the value, it's easy, he can calculate the value, probably exclude some part of it. But what about the bankruptcy? It's going to be a very difficult task to sell such a property where there is a court order of giving a specific space to the wife. This probably I have already touched. It will depend upon the area, which school of thought is there, and whether this will be included or not. So there could be a status. I was just reading the personal guarantee application form. When the personal guarantor himself files it, very interestingly, they also say what has to be the marital status. And they have written all this: married, unmarried, separated, divorced. So that means the logic of legislature putting this is they are trying to somewhere capture the personal laws in case of insolvency, PG insolvency. This was a very interesting discussion we had last time in NLU. Excluded debt. Now, these all debts are considered to be excluded debts. And normally, as an RP, what we see is what are the violation and breach done by the corporate debtor, and ultimately those violations are coming down to the PG. So sometimes it might happen, let's say a company has done some violation. Let's say there is an environmental violation by the company. Let's say British Petroleum did something. There is some penalty imposed. And you know that that law also imposes penalty or cost on the promoters. So the concept of vicarious liability is there, strict liability is there. Now, vicariously, suppose the promoters have been made liable. It could be drug and cosmetic law, it could be environmental law, it could be any law, it could be SEBI law also, whatever. Now, this excluded debt interestingly says that it is excluded. So, liability to pay fine imposed by the court is excluded. Similarly, liability to pay damages is excluded. Interestingly, it says statutory, contractual, or legal obligation. In all the three cases, breach is excluded. Now, and I pose this question to all of you. When I am not able to pay bank, don't you think it is a obligation which I have breached under the contract? It's ultimately a financial contract. Can we say that it's an excluded debt? Language is very general language is used. They also say statutory obligation. Under the statute, you were required to pay something you couldn't pay, but that is not included as a debt. liability to pay maintenance. I suppose now that point is clear, which I was trying to put. Maintenance could be to wife, maintenance could be to parents also. See, these are all maintenance laws. Maintenance could be under all these laws. We need to basically assess the individual from this aspect of maintenance and see how much things could be excluded. Coming back. Now, under clause 1 and 2, do you think that these two exclusion means that if the insolvency is triggered, this debt will stand outside? See, we normally have that section 53 waterfall in corporate insolvency. We say that this particular person will stand out from the waterfall. If you remember that EPFO, PF dues will stand outside. Money taken from the home buyer standing outside if no contract has been concluded. So in somebody's mic is on. Yes, participants, what are your views on clause 1 and 2? Can we say that these particular debt will be excluded, meaning thereby they will not be included for the purpose of assessment of repayment plan? Or if I aggregate the asset, will this not form part of the asset? So suppose there is a order by any court on a particular asset, whether that asset will also not come because the debt is excluded. I think this is a very big challenge with regard to excluded debt, how it has to be interpreted.
Sir, what about puff transaction, sir?
Sir, I will come on to puff transaction. It's there in my presentation. I will share my views.
Okay, sir.
In fact, that is the important thing which is happening. In fact, last time the expert committee group of our triple IPA met, and I was also a member of the committee. So we were discussing what will happen to the insolvency cases where POF transaction. The figure from last discussion was around 5 lakh crore is pending in POF transactions across benches. Now that particular will have to be recovered from the PGs, probably those are the guarantors. Now that PG himself files an insolvency or the banker himself files an insolvency. So whether the RP of the CD will file a claim before the RP of the PG. It is actually a never-ending situation where we don't know whether any money will come or not. Further, we have that Gluckridge Capital judgment of Supreme Court, which says that third parties cannot be adjudicated by NCLT. So now third party goes away, promoters remain. Promoters themselves are guarantors in 99% cases. Now under those, promoters get into insolvency. Now they publish a public announcement asking for claim. Now see the plight. RP of the PG and RP of the CD now will get into a fight. I have to take this claim, I have to take this claim. Now RP of the PG will say to RP of the CD, please file a claim of POFE transaction. Suppose I am the PG, what I will say to my RP, sir, you accept whatever POFE transactions are there, please accept all the transactions, let the claim come in. So the claim from the RP of the CD or probably the liquidator of the CD, as the case may be, will be filed in the insolvency process of the guarantor. And now the RP of the personal guarantor will collate that claim. You see a situation how this particular thing will be resolved. The assets ultimately are of the PG, available either for the committee of creditors of the PG or maybe under some law or court order or maybe obligations which is breached according to this statutory, contractual, legal, whatever, they will also come into this aspect. So how this tantrum will be solved, I don't know. But yes, this is happening. There are court orders where now the court has said that promoters will now have to be implemented through RP of the personal guarantors. There have been orders and orders now where they are asking the RP of the PGs to take over the matters. And now I don't know, the aspect of civil recovery is going to be a question. Yes, criminal action can still continue. But I think creditors will get nothing to pursue for criminal action if they are aware that the PG does not have enough money to satisfy the claim. So this was my thought. Another aspect, in fact, another school of thought, I would say, and this is again, I am saying it for deliberation purpose because there is no conclusive evidence on this to the best of my knowledge. Yes, Makija sir would enlighten us on it. The first one, if you see, what it says is liability to pay fine imposed by the court or liability to pay damages. People have still gone inside and interpreted what is fine and what is damages. So what is fine and what is damages and what is penalty is also altogether a different ball together, all different. We don't know whether it will be categorized in A, B, or C. But whatever it is, ultimately it is a claim against the estate of the PG. That's for sure. So one also possibility is to exclude this debt. One person who gets an order against him, he should not tomorrow use that order and file an insolvency in his personal name. I'm trying to say that if I have a guarantee deed, I have an invocation of guarantee, I can go and file Section 94. I can enjoy the moratorium, I can go for resolution, or I can go for bankruptcy. But if there is a court order against me, and to defy that court order, I use Section 94, probably this excluded debt will come into picture and I will not be able to initiate Section 94. That is another angle to this excluded debt. One aspect of getting aggregation of all the creditors in the COC is that we do not know how many creditors exposure is there of the PG. One fine thing which I have suggested or probably our clients are doing is we are going for civil reports to get an idea of what the exposure of that individual is. Because probably the civil, and I'm using the word civil only as a general term, there are other credit rating agencies also in India, where if you could get the report, it will be available to the financial creditors only or the person himself. So as an RP, today we are not having any legal backing to get it, but we can request the bankers to give us a civil report of the PG from which we will come to know he or she is exposed to how many creditors. Mostly the financial creditor data we will get. Second is income tax return details. We have got some cases where even the PGs are not traceable or overseas. In that case, need to make a communication to the income tax department and they can give you the access to the income tax returns. From return, we will come to know, let's say some interest is being deducted, some TDS is paid, we get to know what is the FD, what is the property, any purchase sale, all those things can be tracked from the income tax data. Another important aspect, which probably in one of the cases we used was KYC. So once we get to know what was the last active bank account of the PG, we could be finding out the KYC with regard to that particular account. If you see RBI Master's directions on KYC, they give you a huge detail about that particular PG. Assets, liability, everything is to be updated. In that particular direction, there are three categories: high risk, low risk, medium risk. All those categories are there. According to that, and generally I'm saying, depending on the risk, 3 years, 1 year, 2 year, whatever is the category, KYC has to be updated. Now, in that KYC, we will find everything. What is the asset declaration? What are the latest income tax return? Without which their account becomes inoperative or inactive depending on the usage. And without KYC is complied, they cannot use the bank account further. In fact, in one of the case, and I don't know that gentleman is here in the participants or not, it happened so that once the KYC of the RP, no, bankruptcy trustee was updated, all the defaults of the PG got reflected in the RP's profile. So that is also some caution we need to take. I think it was a Mumbai case. There is some application file in the NCLT to give a direction that it should not happen, that the defaults of the PG are also getting reflected just because we are getting access everywhere. So that is again a thing which we need to take care.
Nipulji, another revenue is NESL, recent revenue.
Correct, sir. Now, sir, I will tell you one interesting case of NESL also. I happen to be appearing for one of the parties in that matter. What is happening because of NESL and because of, I would say, uh, zeal to implement NESL, the regulations now have been amended and proposed amendments are also there, which says that once the record of default is there, you please accept it and admit it. So as far as financial creditors are concerned, they are somewhere protected. Now, in one of the case, what had happened was there was a dispute between borrower and the bank. Borrower was asking for his guarantee deed because he wanted to move Section 94. Now, the bank said, no, we are not going to give you the copy of the loan document, which is illegal. They have to give. As per RBI circular, as per RBI norms, they have to give. They did not give it. Now, the personal guarantor moved High Court asking for a direction against the bank. Now, that bank was one of the reputed private sector bank. Bank said, sorry, we are not going to give because we are not amenable to writ jurisdiction. So on the maintainability, it goes away. They can go to RBI, but we are not going to give it. Parallelly, what the bank did was they filed for record of default in NESL. Now, if you see NESL structure, what happens is as a borrower and as a banker, you both need to register. Now, if the bank register and they want to send you that notice, that's I think Form B, before that registration, they need to upload the document. Similarly to like we move for Section 9 as an operational creditor, we register, we move, upload all the documents. Then the notice is sent to the other side, 1, 2, 3, and then the Form D is generated in case of CD. Now, in case of PG, before sending Form B, normally what banks are now doing, financial institutions, they register it. Now, the problem in this case was bank was not cooperating, and in fact, the matter was before High Court. There was issue on the maintainability, which was ongoing. The matter was parallelly pending. They moved NESL and it started giving notice to the borrower. Now, if you see NESL structure and if you go in the NESL login, it is compulsory that the person who has asked or recorded that default. So suppose I am the X person, bank is B. Now bank B has registered me to be a defaulter and therefore notice should come to me. They have to upload the loan documents and especially the guarantee deed document. Because they want to now go under IBC, initiate personal insolvency against me or maybe the corporate insolvency against me. The problem with that particular situation is that NESL started sending notices without even asking for the documents because it is all data driven. They punch in some documents, upload some documents, and the notice starts going, and then it is record of default, it is deemed to be authenticated or disputed. So this is also a very interesting thing where now NESL needs to be taken care very seriously. We wrote to NESL in that matter. We means the person who was involved. They wrote to NESL, then NESL in turn wrote to the bank, and then bank uploaded the document. So without uploading the document, tomorrow some actions can be taken. So this NESL still is at nascent stage, has not got into a mature stage. That is what my impression of this NESL record of default is. Now, this was one of the case where we were able to get a combined repayment plan approved by NCLT. Now, if you see, there is no provision as far as law is concerned that the combined repayment plan can be approved, but court in its wisdom allowed it under Rule 11 because I think these were 5 people, so 5 of them were brothers. So all brothers had joint property, so even otherwise it was not possible to sell them individually. They gave a common repayment plan and this was approved. So you can see common repayment plan was there. Interestingly, I think in 3 of the guarantors case, it was same COC constitution, but in 2 of the guarantors case, it was different constitution. So 5 COC to be done together and 5 repayment plan to be passed together. But we were able to do it because majority of the COC were same. So this may not be possible in case where the COCs are different. So this is the citation for common repayment plan. You just all can have a look at it. And I will also share in the same case, repayment plan was approved. I think it was approved for some 11.5 crores or so. Some 5.5 crores we were able to recover. After that, they defaulted. And now we have gone for bankruptcy in this matter. The same case, same citation, same case, further orders of bankruptcy has been there. And after apprising the court that we have some apprehension, the creditors were able to get a bankruptcy order, and specifically in the bankruptcy order, 141(1)(f) has been mentioned. So it's very interesting. I think most of you must have been seeing this 141(f). But if you read this order, specifically, court was kind enough to record it in the order that the bank, this PGs, will not be able to leave the country without permission of the NCLT, and this order should be communicated to the immigration authorities directly from the NCLT registry, so that it should not happen tomorrow they leave the country and we are not able to get the amount back. So again, this is a new learning for all the, I would say, BTs, all the RPs, that kindly make a mention if you think that you have a flight risk for the PGs. Well, it will all depend on the PGs. In Gujarat, we have that flight risk. Normally, we always get this specific instruction in the order itself. Now, I would now just touch upon the recent rulings. So we have this recent ruling of NCLAT, and I think probably in some of the webinars you might also have discussed it with. It says that once the 12 months are over, that particular person who is bankrupt, the PG, will get discharged if the discharge has not been filed by the bankruptcy trustee. Even in that case, the bankrupt will be discharged. So this is an interesting case where probably because of ABC reason, the bankruptcy trustee did not move ahead for extension of time, and therefore this order has come. Though NCLT had rejected it, but NCLAT has allowed it and remanded the matter back to NCLT to consider with regard to discharge of the bankrupt. Another recent case, so we have 141(1)(f), which I have discussed, not permitting the bankrupt to go out of the country without permission of the NCLT. Now NCLT has permitted in this case, subject to certain condition, some, I don't know exact figure, but I think some 2 crore rupees or something has to be deposited by the son of this applicant, and the itinerary was there. I think some 2 months or so was permitted to go outside India, and therefore this is again happening. So as a bankruptcy trustee, we will have to be on toes with regard to tracking of that particular person's travel itinerary also. So first of all, you cannot permit him to go outside India as a bankruptcy trustee. He needs to move an application before the court. Only court can permit, subject to whatever certain conditions. Court can deny it also. Now the question comes whether the court can ask for deposition of passport of the bankrupt. Yes. So that power has also been confirmed by NCLAT and further by Supreme Court, that NCLT has the power to ask the bankrupt to deposit the passport also. So yes, passport can also be deposited before the NCLT registry, can be permitted by a court order to be taken, travel abroad, come back, again deposit. So all these things are now happening. So the bankruptcy is now not a very easy task. I don't know how this 12 months timeline will be complied, but yes, new challenges and new things are coming every day. Then exclusion orders are also coming. I just shared some orders where exclusion has been permitted because there was an attachment by the enforcement directorate on the assets. So PG bankruptcy also period can be extended. I had given that reference of first order because that order discharge was not filed. Now, if the extension would have been taken by the BT in that case, probably that would have followed this fate, excluded time would have been permitted. I think it's already 5:11. I'll just flip through the last 2, 3 cases. So contempt of court also lies in the case of bankruptcy, and courts are ordering, and therefore it is important that the PGs also respect each and every court order. If no court order or any court order is complied, then contempt can be initiated. That is also now there. Another aspect is that of check bouncing. I think some webinar would have been there on this also, because there was a Supreme Court order that 138 protection will not be there on the PG. I have a different view. That particular judgment only talks about the interim moratorium. It does not talk about the final moratorium. It was not a case of Section 100 moratorium. In my view, once the bankruptcy or the insolvency is finally admitted, everything will turn into a claim. Yes, criminal action with regard to imprisonment and all can continue. But as far as the recovery of money is concerned, my view is it will be hit by moratorium. So I think we'll just now close the presentation because I've covered whatever I wanted to.
Thank you so much, sir. And we got Dr. Ashish Makija, sir, with us now. Thank you so much for the wonderful presentation. Sir, should we take up the queries at the end, or we can do that because there are few in the chat box as well. Dr. Ashish Makija, sir, I request you to please present the memento for this wonderful, wonderful session that we have.
Yeah, absolutely. I think it is always a delight to you see share the dais, or maybe they share the screen nowadays, of course. Nipun, on behalf of IPNet and the entire fraternity family, we will request you to please accept this physical copy. Naturally, Mr. Udaraj Patwardhan will send it to you, but we request you to accept it virtually.
Thank you so much, sir, for the kindness and the opportunity given me. It's always a pleasure to be with you. In fact, I feel very elated to be with you on the discussion wherever the forum permits. We look forward to you, sir.
Absolutely.
Thank you. Thank you so much.
Right. Thank you. I think you are going to stay here so that we can have a greater discussion, because I don't have any presentation. I'll just deal with some of the issues, and I think we'll leave it for more for a discussion. I think Mr. Vakati Balasubramaniam ji has a question. Sir, yes, sir. You can ask your question first, and then I'll start. Okay. Are you able to unmute yourself, sir? Okay. Anyway, I think he'll try, and in the meantime, let me start. Friends, a very good evening to all of you. I think this has been very engaging. I've also been listening to him. Of course, I could not join in the initial stages. I was coming back from certain seminars, so I was on the road for almost 2 hours. So, friends, I think Mr. Udayraj Patwardhan must have. Namita, should I start, or do you want to carry? So sorry, I jumped the gun. I don't know.
No, sir, we just have Mr. Rajesh Shah who wants to introduce you. So,
There's no need to. I think Mr. Shah, you can finish it in one line.
Agreed. There is no reason for that. Let's start with the interaction. That's more important.
Yes, that is more important. Thank you so much. I think it is always a delight that on the IPNet forum, which we started just 1 year ago, you see, we have been able to organize more than 56 seminars by webinars by now. In as many weeks as we have existence, we have been conducting those webinars, and these webinars are being conducted by the regional teams, zonal heads, regional heads, not by the IPNet central team. So therefore, I think IPNet owes a lot, and the existence of IPNet is because of these people who have been contributing week after week. So I think I really appreciate, and I would, and of course, we are going we are going from one loop to another loop. And as all my friends are aware, I think Mr. Patwardhan must have announced, and I must also take some time to announce that we are organizing an IBC conclave on 1st of November in New Delhi, which is a physical, you can say, conclave. I will request each one of you to please register, and at least, and a lot of people from outside are coming. And you get 4 CPE hours also. Nipunji is also coming. We have invited him. And a lot of other top experts and speakers will also be there, friends. It will be a real delight to welcome you in New Delhi. So we have made fantastic arrangements, and I can assure you personally that you will not regret it. Rather, you will enjoy it, and you would like to have such kind of fun conclaves every month. So that is what the whole, we were working very hard to make it absolutely successful and an event to remember. Okay, so friends, now let's come back to this topic of the day today. I think Nipunji has covered broadly the grounds and dealt into a greater detail, dealing with the practical aspects also, which is typically required. We don't want theory, we want the practical aspects to be there. I will deal with 4, 5, 6 issues broadly, and then of course we will field questions. Nipun will also be there. Both of us will try to answer to the best of our capacities and based on our experience on what we have been doing. And a few of the earlier questions which were there, I have my own opinion and thoughts. We will definitely cover that also in a little while. Now, friends, one of the aspects which has been there in personal insolvency and bankruptcy. Okay, one point I think Mr. Udayraj also mentioned about adjudication, and I think we were talking about what is meant by adjudication. So let me deal with that in a very, quick manner. Friends, why the word adjudication is appearing in earlier laws, particularly Partnership Act and other things? In fact, to my knowledge, I think that provision which Mr. Udaraj Patwardhan quoted, probably that has been deleted by IBC also. I think we'll have to look at the schedule, what has been deleted, but that is my understanding. I may be wrong. Now, the point what I'm trying to convey is adjudication. Friends, earlier we had two laws. Provincial Insolvency Act 1920 and Presidency Towns Insolvency Act of 1909. In that, Section 6 is very important. Section 6 used to say, I don't know how many of you have read it, but I was very fortunate in my LLB when I did my law. I think I chose Provincial Insolvency Act 1920 as one of my subjects. Probably nobody does that, right? Those who are lawyers here, probably nobody does that. But I did that, never knowing that in after, you see, maybe 30 years, the law will come and we'll be dealing with it in a practical sense. So under Section 6 of Provincial Insolvency Act 1960, a person can be adjudicated as insolvent provided he has committed an act of insolvency. So the basic word which is used there is act of insolvency. Now, what is an act of insolvency? There are a lot of issues which have been mentioned there, that if a person has sold all his properties to the detriment or prejudice of the creditor and so on and so forth. But the most important is that if he is not in a position to pay his debts to the creditors. So if a person is not in a position, then an application can be, then he has committed an act of insolvency, then an application can be filed for his adjudication as insolvent. So typically, what do you mean by adjudication? Very simple formula, friends. Adjudication is equal to order of the court. When the court declares a person that you are insolvent, the person is adjudicated as insolvent. Now, if we want like to compare that, we would like to compare that with IBC. I think we need to compare it with Section 126. Now, 126 very clearly says that an order will be passed, you see, by the tribunal declaring a person as a bankrupt. So when the order under Section 126 is passed, then we would say that the person has been adjudicated as insolvent. Now, where I'm coming from, you have to read 126 with the definition of the word bankrupt. Now, I'll just read that definition for you. Yes, it is given in 79, clause number 3. It says bankrupt means a debtor who has been adjudged means adjudicated only, as bankrupt by the bankruptcy order under Section 126. Now, this is something which starts the process of bankruptcy. Then the person is adjudicated as a bankrupt. So primarily, I would say that under the previous regime, insolvency is equal to bankruptcy because there was no process of repayment plans. Like we had CIRP and now we have the IRP. So IRP is a, you can say, a preliminary process of adjudicating a person as a bankrupt. So earlier insolvent word will be actually equivalent to the bankrupt under IBC. And therefore, we will have to really read those, because if you also look at one of the another definitions, undischarged bankrupt. If you read section 79, the definitions, there is no definition of undischarged insolvent. They have defined only undischarged bankrupt. So to that extent also, adjudication would typically mean that. Now, one of the problems which have come before the adjudicating authorities and also the RPs, who have become the RPs of the insolvents, that when a no repayment plan comes, what should be the situation? What should we do? So number one, I think most of the things are clear now, that in case no repayment plan comes, naturally RP is supposed to file again a report, because earlier it was written that he will file a report only on the you see on the meeting, and which is considering the repayment plan. So if there is no repayment plan, whether you want to hold a meeting, whether you will file a report or not, well, that is very clear now. I think there have been certain orders by the NCLT where they very clearly say that yes, you have to still file a report. And once you file a report, then the court will say that there is no resolution plan which has come. And therefore, now the big question, if you go to, because I think most of us are aware that bankruptcy is not automatic after the insolvency. Just like in CIRP, if CIRP fails for whatever reason, there is automatic liquidation. Of course, RP files an application, and on that basis of that application, order is passed under section 33, but it is automatic. That means the moment the CIRP ends, liquidation starts from the next day. But in case of personal insolvency, the moment personal insolvency ends, bankruptcy does not start automatically. That means it requires a separate application to be filed. Now, that application, of course, as we are aware, section 122 and 123, you have to file that, right? Either a debtor can file or any creditor can file. But we cannot ignore, my dear friends, section 121, application for bankruptcy. So application for bankruptcy cannot be filed in all situations. It can be filed under only three circumstances which have been mentioned. And it is clearly mentioned, just remember a simple formula: 100, 115, 118. That's all. If an order has been passed by the adjudicating authority under section 100, subsection 4, or if an order has been passed under section 115, subsection 2, or it has been passed under section 118, subsection 2. Now, very simple. What is 100 and 118? Let's go from the backwards. 118.2 says that if the plan has been approved but the debtor does not comply with the plan, then he is entitled to be declared as bankrupt. He is not declared as bankrupt. He is entitled to be declared. Therefore, the entitlement comes with the debtor or with the creditor to file another application. So that is only an entitlement. So that is one situation where the repayment plan is not completed or it ends prematurely without following the entire process. Second is that under 115.2, when the order is passed, when the plan is rejected, when the repayment plan is rejected by the adjudicating authority, then then the debtors and the creditors can become entitled to file. Now the situation, and the third, of course, is, as I mentioned, 100 subsection 4, where on the report of the RP, the adjudicating authority says that this process has been, proceedings have been started because of fraudulent nature or to defraud the creditors. In that case also, directly, you see, the bankruptcy can be started and entitlement can be there. But it does not cover a situation where the repayment plan does not come. If the repayment plan has not come, COC has not, sorry, not COC, the creditors have not considered it. If creditors have not considered it, then how can there be a rejection? And if there is no rejection, whether under section 115(2) will apply or not. So that was a big legal question where the most of the adjudicating authorities across the benches now, it is not limited to one bench, whether it is Ahmedabad, New Delhi, Mumbai, all benches are passing a similar type of an order. They are saying the effect of non-submission of the repayment plan is equal to rejection of the repayment plan. Please remember this formula. Non-filing of the plan is equal to rejection of the repayment plan under section 115 subsection 2. So therefore, they say, oh, we are granting now liberty to the creditors or the debtor to file a bankruptcy application, because it would otherwise it would have created a void and the insolvent would have taken advantage. They submit a plan, rejected by the creditors, rejected by the adjudicating authority, then they get entitlement under section 121. So this would have been a very, very restrictive kind of a thing. And all the insolvent would have said, okay, we are not going to submit the plan, do whatever you want to do. Because then it will be a closure of the insolvency. I become a normal person and no one is entitled to file a bankruptcy petition. So to cover that situation, of course, this is not in the law. This has not been tested by Supreme Court so far. It has been tested by NCLAT. NCLAT has agreed to that. But at the end of the day, we need to have a conclusive judgment from Supreme Court. But this is the law as it stands as of today, that in case there is no repayment plan, the person can still become entitled. But my request to you is, as an RP, ask for a specific direction from the bench that please give me a liberty to file bankruptcy petition, not me to the creditors or the debtor to file bankruptcy petition under section 121, 122, 123, whatever it is. So this is one of the important aspects which you must take care while you file such kind of a report. This is very important. Now, the second aspect, I think Nipunji was Nipun was covering, talking about the excluded, you see, assets or excluded debts. Both of them were being covered. Now, one of the important aspect is when we talk about excluded debt, I think he covered very fairly 4 points which were there. And those four points were that fines are covered, damages are covered, maintenance is covered, and student loan is covered. So 4 aspects, right? I always call it as FDMLA. It is easier to remember that way, right? Fines, damages, maintenance, loan, typically student loan, and any other debt as may be specified by the government. But that has not been done so far. Now, the question which arises is, and that question arose actually before the NCLAT Chennai bench, whether the penalty imposed by a regulator like SEBI, whether it will be treated in the category of a fine or not. Friends, from a legal standpoint, let me explain this to you. Fine typically means when a conviction occurs. Whether it could be a civil case or it could be a criminal case, that doesn't matter. Fine can be imposed by even by a civil court also. There has to be a conviction. Now, if and in IBC, you can see those sections, right? Offenses and penalty section. Of course, the word penalty is very confusing to that extent. But please let us also understand that if the word offenses and penalties chapter is there in part 2, there it is in part 3 also. In part 2, section 68 to 77A cover the word offenses and penalties. And if you look at very carefully, every section from 68 to 77 starts with the word punishment. So fine is a punishment. Similarly, imprisonment is a punishment or both. So in all these sections 68 to 77A, you will find these words, fine or imprisonment or both. Now that can be imposed only by a court. A tribunal, we are all aware that from 68 to 77, NCLT does not have any power. Similar sections are there, 184 to 187, which fall in part number 3. So these are few sections which typically talk about fine, and the word used is fine there. But then we have some penalty sections also. And those penalty sections are typically, you can find them in like in section 65, a penalty can be imposed up to 1 crore of rupees for mischievous and frivolous litigation which could be filed. But and then NCLT has got the power. And similarly, you will be noting that in Companies Act also, registrar of companies can adjudicate penalties, isn't it? Similarly, say in and SEBI can also adjudicate penalties. Now, whether these regulatory bodies which are imposing penalties is equal to fine or not, that's a big question. Because if it is considered as a fine, then it will come under excluded debt. If it does not come under fine, then it will not be an excluded debt. Well, we have a judgment now, which was passed by the Honorable NCLAT Chennai bench. It was passed on 30th April 2025, this year only. And the name of the case is, if you wish to note down, or maybe I can request Namrata ji to write down in the chat box, GV Mary, Marry, Mary, okay? GV Mary versus Union Bank of India. And this is by NCLAT Chennai, and it is dated 30th April 2025. Now, what does this judgment say? This judgment has dealt with all these aspects, and ultimately they came out to a conclusion. What they say? They say even a penalty imposed by a regulator is equivalent to fine. It can partake the character of a fine, therefore it will be an excluded debt. So that is what the judgment says. Whether you agree or not, that is a separate aspect altogether. In fact, if you ask me, it is not a correct opinion. I would still wait for the Supreme Court judgment, but till that time the judgment comes, we are all bound by the NCLAT judgment. You are also bound, I am also bound. So we may have a difference of opinion, but we have to follow the law. So therefore, we must follow this particular law. So adjudicatory penalties also will be covered under the word fine. That is what the Honorable NCLAT Chennai bench says, right? So that is what I wanted to show it to you. Now, the third aspect, of course, I'll just cover one or two more aspects. Mr. Udiraj, I believe I have that 10-15 minutes slot now, or do you want me
Yes,
to?
we have some time. Yes.
Sure, okay. I'll just cover 2-3 more points, not in greater detail. And I just wanted to cover very broad, you see, points which have been decided by the adjudicating authority so that everyone is aware of this. The other aspect is that if you look at section 112, my dear friends, now in that very clearly it is mentioned that the time period, not 112, sorry, it is, I think, 122, yeah, where the application for the bankruptcy is to be made within a period of 3 months, isn't it? So now if the period of 3 months which is mentioned, then whether this, supposing somebody comes to the court after 4 months, what happens to that? Will there be a condonation of delay? Will the NCLT have the power to condone those date delays or not? Well, friends, Hyderabad bench of NCLT in Central Bank of India versus Usha Agarwal. So Namta ji, please, if you can just write it again. Sorry, I'm just asking you to do that. Central Bank of India versus Usha Agarwal, and that is Hyderabad NCLT. It is dated 11th of December 2024, 11/12/24, where they have said that the 3 months time period which is appearing will be treated as directory and not mandatory. So when they are treating it as directory, that means the time can be extended. So they say that this is possible. So this is one another thing which I wanted to bring it to you. Now coming to the most important aspect, friends, and that there have been a lot of confusion into that. And recently there have been an NCLAT judgment also on that. And NCLAT is very clear. Most of the benches are also clear. But this issue, I would like the Honorable Supreme Court to decide on this. What is that issue? Whether NCLT has got the jurisdiction to handle the cases of personal guarantors, regardless of the fact whether the CIRP or liquidation of the corporate debtor is pending or not. My personal opinion on reading of 60 subsection 1, subsection 2, subsection 3, and I'm not stopping it here, my dear friends. And I'm going back to Lalit Kumar Jain judgment by the Honorable Supreme Court. Para 95, para 99. I think these two paras have probably never been shown to Honorable NCLAT. And in those two paragraphs in that Lalit Kumar Jain judgment, coupled with the plain reading of 60 subsection 1, 60 subsection 2, 3, and also the definition of the adjudicating authority which has been brought in the rules by IBBI, the meaning is absolutely clear that even for a personal guarantor to CD, the jurisdiction can lie either before NCLT or before DRT. NCLAT has very categorically mentioned that it is always NCLT whether CIRP or liquidation is pending or not. Well, we are all following that. No problems in that because we have to follow, as I mentioned. But I would like to see the Supreme Court intervention here because with due respect to NCLAT judgment, I do not agree with that judgment. Now, why I'm saying so also? Because not only the Supreme Court judgment, which has not been considered, there is a judgment by Honorable High Court of Madras. Madras High Court has also dealt with this particular aspect, whether DRT, and this is a division bench judgment, not a single bench judgment, where the Chief Justice of Madras High Court was also one of the bench members. And they have very clearly decided, my dear friends, that the DRT shall have the jurisdiction if the CIRP or the liquidation of the corporate debtor is not pending. Very categorically they have mentioned. But probably to the NCLAT, neither the High Court judgment has been shown, nor the Supreme Court judgment, Lalit Kumar Jain. Those two paragraphs have been shown. They have actually quoted para 100 from Lalit Kumar Jain, but 100 they have probably, that is my opinion, they have actually misread it. It was in a different context altogether. So they have just relied upon two sentences, which was out of context totally. So this is very important, my dear friends. And the judgment, of course, if you wish to read that judgment of Madras High Court, you can read that. It is Rohit Nath. Again, Namrata ji, please. Rohit Nath versus KEB Bank, High Court of Madras. So I'll repeat, Rohit Nath versus KEB Bank, High Court of Madras, 30th March 2023. And this is a division bench judgment. So in these judgments, very clearly it has been mentioned, and they have also gone to the rules, and they say when rules also provide that either the DRT or the NCLT can be the can have the jurisdiction. So how can we simply say that only NCLT will have the jurisdiction? And if you also, friends, read carefully 60 subsection 1, 62 and 3 in conjunction, don't read 61 separately. 61, typically everyone gets confused by just reading 60 subsection 1. 61 simply talks about territorial jurisdiction. It does not talk about when that territorial jurisdiction is to be, started. It gets started because the point is, there is a car, there is a motorcycle. Does it go to the destination on its own unless you ignite it? Ignition has to be on. So unless the CD's CIRP or liquidation is pending, that is the ignition. I can always say I am parking my car at home. Right. But the point is that at the end of the day, you have to see the other sections very carefully. Subsection 2 starts with the word without prejudice to subsection 1. And not only one non-obstant clause, my dear friends, it also contains a second non-obstant clause. It says, notwithstanding anything contrary contained in the code. I've never seen a section which contains this kind of a language. Without prejudice to subsection 1 and notwithstanding anything contrary contained in the code. The jurisdiction will lie only if the CIRP or liquidation is pending. This is what has been smartly interpreted, very beautifully interpreted by the Honorable Supreme Court. And Honorable Supreme Court in para 95 of Lalit Kumar judgment, I'll request you to please read that. That clearly says that without prejudice means that subsection 2 overrides subsection 1. So if subsection 1 gives a territorial jurisdiction and if subsection 2 overrides subsection 1, where is the question of only applying 1? Then we have to apply 2. And 2 very clearly says if the CIRP or liquidation is pending, then there is a jurisdiction. And then let me also give you one more very short argument. Subsection 3 talks about transfer of proceedings of the personal guarantor to corporate debtor from one court to NCLT. Now, friends, tell me, if I go by 60 subsection 1, and if at all times, as NCLAT says, that the jurisdiction will always lie with the NCLT, there is no other jurisdiction according to NCLAT, then where is the question of transfer then? Why subsection 3 was inserted? Was it redundant? So idea was that, look, so there are two situations. Prior to CIRP, I can take personal guarantor to corporate debtor to an insolvency. I will start from the DRT. Supposing corporate debtor is located in Mumbai and the personal guarantor is located in Delhi. And if CIRP of the corporate debtor is not pending, then I will take their personal guarantor to DRT Delhi. Later on, if in NCLT Mumbai, the corporate debtor CIRP starts, I will use 60 subsection 3 and I will transfer that case to NCLT Mumbai. No problem. This was the intent. If all the time these proceedings were to be started only in NCLT, do you think that the parliamentarians made the redundant section 60 subsection, within the question of transfer will never arise? So looking at these arguments, I think somebody has to argue properly before NCLAT. So typically, or maybe before the Supreme Court, bringing all these facts. So if these legal positions are brought in, and I'm so happy that High Court of Madras agrees with what I have the opinion, and I hope it is upheld by Supreme Court sometimes. I don't know if somebody has to challenge that. Okay, I believe Nipun is going to challenge it now. Okay, please do that. And now, one more aspect is very small aspect, that whether before the passing of the bankruptcy order, supposing a creditor has passed up or given a liberty, like supposing the insolvent has not submitted a resolution plan, report is filed by the RP. Based on that report, can the court say we are granting liberty to the creditors to file bankruptcy application? Now here one case came where the insolvent said that, look, before passing such an order, giving a liberty, I was never heard. Though I have not submitted a resolution plan, repayment plan, does not matter. Principle of natural justice require that I should be given an opportunity of hearing. But ultimately, the matter went to NCLAT, and NCLAT said, look, you did not cooperate. You did not submit the repayment plan. And now you want a hearing. What kind of hearing you want? So they say there is no flaw. They have simply granted a liberty. So before passing an order under section 115, no such hearing is required. So I think that is probably favoring the RPs. So you file a report, file, smile and go. Okay. So you don't hear the insolvent or the person. So before the entitlement position is carried out under section 115(2). So friends, I just wanted to broad base. I don't want to overburden you with more cases. I think I would like to stop here. If you have any questions, let's leave some portions for the questions. I know a lot of questions are going to come, but for friends, first of all, now one more request. I think if everyone can open their videos, I would say that we don't like to speak to blank screens. We'd like to see smiling faces. This is fantastic. Now this is something great. Now, friends, one more request, as I mentioned earlier, and Udayaraj is making a great effort. He is the program chair for IBC Conclave, and he has spoken to top speakers, across India. So many people are coming. So I would request, please do not miss that opportunity. I'm repeating once again. I'm requesting each one of you to please attend it, and you will really like it. I'm telling you, it will be a experience you will never forget. This is what we are going to make it. It will be a different conference than whatever conferences you have attended so far. That is my promise. Okay. And I look forward to welcoming you, each one of you, in New Delhi. Okay. So over to you.
Thank you. Sir, before we open it for everybody to put up queries, and Advocate Nipun wanted to interact with
Yes,
you on some issues. So
Yeah,
let us deal with that, and after we have done with that, then we can go to others. There are some questions in the chat box also, which also we will take.
Absolutely, sir. Go ahead. I think
Please go ahead.
questions from participants are easier, but from Nipun, obviously, they are going to be tougher ones.
So it is only for the purpose of deliberation. Because I had given my view, I wanted that you also share the views on the issues so that it will be good for everybody. So I think the first one was with regard to taking control and custody of the asset by the RP in insolvency process, because bankruptcy process, it is very clear. The only problem is with the insolvency process, the stage one.
Okay. So what is the question? I mean, the point
So
is
whether control and custody has to be taken or not.
Okay. Good question. In fact, Nipun, I will tell you there was in one of our cases, what happened? The RP came and he wrote to the banks, he said, please freeze the accounts, just like in CIRP. Do you know what we did? Of course, he was one of our fraternity members, but since we are defending our client, we had to file a contempt application against him also. I said, how you are taking control? You cannot. See, idea is, right? I'll tell you. The idea of what is the idea of insolvency? Idea of insolvency. And one more aspect which Nipun was mentioning about restrictions on the bankrupt. Right? There are restrictions. He can't travel abroad. He can't do this transaction. 5, 6 restrictions are there. And similar restrictions you will find in the fresh start process. But you will not find those restrictions in the insolvency process. So there are 3 processes. Of course, fresh start has not been notified, but similar restrictions you will find in fresh start process. Very interestingly, I mean, a guy who is economically weaker, belonging to economically weaker section of the society, the restriction says you can't travel abroad. Who falls under fresh start? Who does not have debts more than 35,000 rupees? Can he travel abroad? But at the end of the day, still those restrictions are there. But those restrictions are missing in insolvency. So let's understand the concept. The concept is very clear. That means we are asking insolvent to be a free bird. Keep on doing what you have been doing. Keep on doing your business. Keep on doing your employment. Keep on doing your profession. What have you been doing? We are not stopping you. We are not taking any custody and control of your assets. Your bank accounts are not under my control. Of course, he is bound by the restriction, the moratorium which comes under 100, that he cannot dispose of or sell off his assets. So those restrictions definitely will be there. And if he violates that, naturally, penal action can be taken against him. But as far as insolvency is concerned, he is continuing like a going concern, right? He is continuing. He has to fend for his family, isn't it? He has to pay tuition fees for his children. He probably has to maintain his family. So we cannot stop him from doing this. So no custody, no control of assets unless you have a doubt that he's going to sell it. He want to deceive, you can say, do something else, or you want to fly abroad or a flight risk, that of course is there. Well, you have to have a credible evidence and you can approach the NCLT, and they have been passing orders. As Nipun also mentioned, they will pass that orders. But no custody, no control, please never do that. Okay.
Second one was, sir, that the claim of the PUFE applications by the RP of the CD to the RP of the PG. Whether the PUFE application will end up in just filing a claim and nothing will come out or not.
Okay, this is as you also mentioned, Nipun, this is a very tricky question, and naturally we have to examine on the basis of number of parameters. Number one, whether the PUFE application is still pending or it has been decided. So if it is pending, I'm assuming that it is pending. So therefore, if it is pending, now the question that arises is pendency of a case. Can a claim be filed by the RP of a CD or a liquidator of a CD upon the PG bankruptcy trustee of the PG? Now that is the question which is to be seen. We have seen where there are pending cases are there, claims have to be filed, and they generally are treated as contingent claims, and they are valued at 1 rupee only. So what is the point of filing such a claim? Anyway, has to be filed because it is not crystallized. Yeah, if an order has already been passed by the court, then naturally that claim has been crystallized. That claim has to be filed before the bankruptcy trustee, and he will have to consider it based on, and the payment will be made based on the priority of dues. But according to me, as far as the application, if it is pending, naturally you will have to file it, you have to register your claim, but probably the bankruptcy trustee will register it at only 1 rupee nominal value. That is the whole thing. Yes.
Sir, assuming sir he accepts it also, there is no going change in fate. Ultimately, sir.
Correct. Friends, I've lost my electricity power here, so probably I may be looking like a ghost. So I hope my picture is coming out straight.
Yes, sir.
Okay. Right.
Sir, I think we can open it for the audience.
Okay.
Then let us look at some queries which are there in the chat box first. So
Yeah.
Sanjeev Chaudhary asks, if a suspended director is now insolvent and proceedings for bankruptcy are under process, is RP required to invite him and allow him to attend COC meetings in the capacity of a suspended member of the board?
Sir, can you repeat the question and probably make it more clear? I mean, let us understand.
I will repeat again that the personal insolvency against a guarantor director is complete, and now
Okay.
proceedings for bankruptcy are under process.
Okay.
So that person is also a member of the board which is suspended. So is RP required to invite him in the COC meetings of those meetings
Okay. Now I
where
understand.
he is suspended?
Well, the answer is yes. Because at the end of the day, see, please, acha, okay, now one more thing will be there because, there is a restriction in the, acha, bankruptcy application has not been admitted so far.
It has been admitted, it is under process now.
No, whether he has been declared adjudicated as bankrupt or not, that's a
No,
big.
not yet.
If he is not, right. If he is not, then naturally he is a person in his own capacity. He has to be given an invitation for the COC meetings attending. But assuming he has been declared as bankrupt, then there is a restriction that he cannot act as a director in any company. Then the situation will entirely change. Then the situation will change, right? So then we'll have to think about it that because if he can't act naturally, he can't attend the COC in the capacity of a suspended director. Okay, so that there will be a restriction then. Yes,
because
sir.
he is no longer a director. Yes.
Yeah, because then he says he cannot act as a director in any company. This is one of the restrictions which is there. Look at this. It is given in section 141, subsection 1, clause number A. A bankrupt from the bankruptcy commencement date shall not act as a director of any company. So therefore, he is no longer a director, he is no longer a suspended director. So therefore, inviting him will, I mean, you can send him an invitation, but he cannot attend. If he attends, then it will be a violation of 141. Okay.
Another query.
What is your take, Nipun, on this?
Yeah, Nipun, your views on this. We discussed it a little bit earlier, yes.
Yes, so I think I agree with what sir said. The only thing is that probably in some cases, in bankruptcy, we actually do not have that option that particular asset is still with the director. Because normally this will happen in a case where the suspended board, let's say there is land which is in the name of suspended board or promoter, and the company is having building on it. In that case, normally insolvency process of CIRP and PG together will yield some benefit. So ultimately, his contribution in the meeting only would be, let's say it's an MSME or the sale of assets is fetching something. Otherwise, it's of no use. Even otherwise, he cannot enter into any contract. I discussed that particular point. So calling him is just, I always say it's only a voice, not vote. Even if you call him, he just has a voice. He doesn't have a vote.
Correct. So I think we'll have to look at in the totality of 141, right? So restrictions not to enter into a contract, not to act as a director, I think both have to be read together. Yeah. Okay.
Yes. Then we have two questions. One by Mr. Kedari Narasimha Rao. Sir, could you please touch on the usage or sanctity of detective agency reports on asset tracing of PGs?
Okay. See, I have been, just give me a moment, friends. Just give me a moment. See, I have been reading on WhatsApp that asset tracing has to be done in case of resolution, I mean, the personal guarantor's insolvency. Friends, why we are doing it? We are not taking the control and custody. Why we are bothered about it? The point is, as an RP, you are simply a facilitator. Please understand, you are a friend, philosopher, and guide of the insolvent. You are appointed from day one to examine the application, which does not happen in CIRP. Once you are appointed, the repayment plan is made with your consultation. So you are involved in the preparation of the repayment plan also. And thirdly, which is very important, which is now they are bringing in part two also, that for the implementation of the plan, RP plays that role. So you are typically a friend, philosopher, and guide throughout the entire process, end-to-end solution. The idea is not to take over or custody of the assets. So where is the question of non-tracing of the assets? The fact of the matter is the insolvent is expected to be extremely truthful. He has to submit a statement of affairs or details of all his assets, which is given, which is his responsibility, ask for it. Now, if some creditor, now the question that arises, which is a collateral question. Supposing some banker knows that there is some property in the name of this insolvent which he has not disclosed. Then in that case, you can ask a direct question to the insolvent and ask him to file an affidavit. He will be truthful. If he files a wrong affidavit or if he makes a wrong statement, you can always take him to the court. So therefore, do not get into yours, because who's going to pay for your asset tracing agency? Please tell me. It is the insolvent who is going to make the payment, or maybe the creditor is going to make the payment, isn't it? Ultimately, it's a part of the cost only. So therefore, I don't think this is required at this stage. We are into an atmosphere in resolution process where there is an atmosphere of confidence, trust, and cooperation. Please remember this. If we do like this, cases will be successful. If we start doing asset tracing activities, then promoters will be totally against you. No repayment plan is going to come. Mark my words. So therefore, let's create an environment of cooperation. And once you are becoming a bankrupt, then of course you have to take over whatever assets are there with the debtor. Okay.
Any inputs on this from your side, Nipun?
Yes, sir. The case which I had cited, where there was a common repayment plan, in that
Yes.
particular case, the State Bank of India was one of the COC lead member. They asked us to appoint an tracing agency, and because of that, the first repayment plan which was given by the guarantee was somewhere around, I think, 9.5 crores. But after finding out that they had some good land in their native village, they then came up with an offer of 11.5 crores. So probably sometimes tracing of asset may help in increasing the negotiation or the repayment plan value. But Makija sir is right. The concept is of trust. But as we all know that only when we find somebody hiding some assets, he will increase the value. In fact, State Bank got furious when they found out that this asset was not disclosed, but it was disclosed in the KYC for some other company which they had given loan, sister concern. From that document, we came to know. And then we got it verified through asset tracing agency that yes, whether this exists or not. And once it was on table, they increased the plan value. So sometimes it might help, but as rightly said, the provision does not say that cost has to be borne by the COC. So if COC is saying you do it, please get the cost approved. Otherwise, cost is the big issue.
True. And secondly, this is one of the important aspects. I think this should be an informal process. Outside this, let SBI appoint somebody. And why RP is getting into it? Let them appoint somebody and trace it and inform the RP. RP will take action against the person concerned. He will file an application before NCLT, or in negotiation they can do that. So that is what the idea is. Of course, promoters here are also very unscrupulous. I think that's the point which we are trying to convey. They are also not honest. We are thinking that they should be honest, but typically they are not honest.
Yes.
Okay.
So we have a
Anyway.
couple of more questions in the chat box. We will quickly take it. We have already reached 6
Yeah,
o'clock.
please. No, I think we can finish those this thing.
Yes. So one is from Mr. Hemant Mehta. Can RP accept claims arising out of partnership or HUF where PG is a partner or Karta. So there is a claim from those partnerships. It is nothing to be claimed from there, but those partnerships or HUFs say that something is receivable from the personal guarantor who is under insolvency.
I think the choice, you see, does not lie with the RP. Anyone who is entitled, they can file a claim. The only thing RP needs to check is whether it is a genuine claim. He has to verify that claim. Documents have to be there. And then he has to admit and verify and admit those claims. So I don't think we should, you see, specify a category of persons that claims cannot be admitted. Even a related party or associate party of the debtor can also file a claim. A wife of a debtor can also file a claim. You will have to admit it. So I don't think the character of the entity matters. What matters is whether it is a genuine claim or a bona fide claim or not. That's more important.
Sir, may I?
Yes,
Sir,
yes.
Sir,
Yes.
my question was basically the claims which are pertaining to the partnership firm, which are owing by the partnership firm. Basically he is a partner of the firm, but the claim is towards the partnership. The amount has been borrowed by the partnership of that firm by that particular PG.
Okay. See, I think you are coming from this concept that the liability of the partners is unlimited, right?
Right,
So,
right.
so there is no difference between a partnership firm and the partners because it is the partnership which consists of only of the partners. Having said that, but please understand, as far as the partnerships are concerned, naturally the liabilities of the partnerships are the liabilities of the partnership at the first instance. Assuming they are not able to pay, then the creditor can take an action. The partnership firm cannot claim. Please understand this. The creditor has got a right either against the partnership firm or the partners. So if the creditor feels so of the partnership firm, they can approach, they want to approach it, then again the RP will examine it, whether the partnership firm has assets or not, whether they have paid it or not, whether what is the share of this person. So all those aspects will definitely need to be examined. But partnership firm as such probably will not be able to file such claims. Okay.
Similar is the case of HUF.
Sorry.
Similar is the case of HUF.
Yes, absolutely, absolutely, absolutely. HUF liabilities are HUF liabilities, right? Karta is only a manager. Okay.
So now I will be putting up next query to Mr. Sanghvi from Sunil Kedia. How to handle joint holding property of bankrupt when the other joint holder is not cooperating?
I think this question Nipun tackled that like some portion is given for maintenance. So it's like a joint property, isn't it? The joint interest is there. So the answer is very simple, friends. The joint properties, whether it is ancestral, non-ancestral, bought together. If they are bought together, how much money this fellow paid, how much money the other fellow paid, what is the joint ownership, whether it is 60-40, whether it is 50-50, you will have to see that. If nothing is mentioned, you can always presume 50-50. So typically, you will include that particular thing. So this is very important. I think by these questions, what I'm getting a feeling, I think Nipun, let's do one thing. Mr. Patwardhan also, let's do one thing. Let's organize a webinar on succession rules also. I think people really need to know what are the succession laws which are there, right? Who gets the property in case the will is there, in case will is not there, how much percentage, how much share. I think this is very important. This will actually solve a lot of questions, particularly out there. So joint holding
Succession of individuals as well as HUF also, because
yeah,
it will
yes,
create
I
lot of wonderful structures.
in fact, we will cover even partnerships also. Let's do that also because partnership also somebody has asked, it's an unlimited liability there. So I think these are important questions which are coming up, sir. Okay.
Yes. So the next question I will take up is, it is debt and default, which is the test even when documents get uploaded in IU. What if document of invocation is not uploaded? Will the section 95 application fail on the question of limitation? Nipunji, you had
Yes, I
discussed
had.
this, so please.
Yes. So in that particular instance where we were for one of the guarantor, what had happened was the bank did not provide us the copy of the guarantee deed. And normally when the loans are going on, And normally we do not ask for a copy of loan documents. It was a normal MSME not got the documents. When they asked for, when they were served with the notice of default, they asked but the bank denied. Against that denial, we went to High Court under writ jurisdiction asking them that they should provide us. But the bank parallelly tried to register the record of default in IU. Now the problem in IU is that once you put it on NESL, you upload the documents, only then it should trigger the notice to the other side. But in case of banks, financial institutions, they are doing it on a very liberal basis that they feed the data, only the data, not even upload the document, and the notice is sent. So when we raise this complaint with NESL, then yes, NESL asked them to upload the documents, then the documents are uploaded and easily as a guarantor we got the documents. Once you get the documents, once you get the guarantee deed, and if it is invoked, you can very well go and file section 94, 95 as the case may be. The problem is that sometimes the documents are not in the possession of the guarantor. That's the only difficulty I wanted to share with you all.
Thank you. Thank you. Next question I will take is, in a PG case, bank has only one FC, filed the claim has been accepted, but the FC doesn't have mobile number of the PG. PG is not communicating with the RP. What can be done by RP in given situation?
Okay.
So
PG
the
not-
PG is not responding in any manner. So I am hoping there is no mobile number and email ID, and I will also assume there is no address.
So instead of asset tracing now, it is PG tracing now.
PG tracing. PG tracing.
We are he's absconding typically.
Well, it
I
happens
have
in
the
some cases,
address,
yes.
but I don't have the email ID and mobile number. Email ID is of the company which is closed.
Right. So this happens many a times. At the end of the day, Mr. Singhania, what you can do is look at who appeared in the court, you see, for that particular insolvency.
None appeared till date.
Okay. So this means this person is totally absconding, right? So
Right.
if he is absconding, he is not cooperating. If you do not have any email IDs, so go to the creditors, ask for the details. So they may have some email IDs.
They don't have an email ID. They don't have mobile number.
Wow, this is fantastic. यार ऐसा बैंक हमें भी बता दो यार, हम भी लोन ले लेते हैं. हम KYC की, यहाँ we are talking about KYC and they don't have any damn thing. I mean, this is surprising. But anyway, be that as it may, well, the option to you is straight away go to the NCLT. You say this is not traceable. I have made all my efforts. सारे efforts उनको दिखा दो. I think they will close that insolvency immediately, which has been done in one of the cases. Probably they will say, okay, file bankruptcy. But traceable ही नहीं है तो क्या करोगे? So you file your report, sir. Your job is to file a report, inform the NCLT as soon as possible.
But
Okay,
Chennai
sir.
NCLT has told us to publish advertisement in such cases.
No, that advertisement has been done. Based on that advertisement, the financial creditor has filed their claim.
Sir, in one of my case, court, while hearing section 94, came to the conclusion that we should not initiate insolvency, we should directly initiate bankruptcy. They ordered bankruptcy. So that probably that situation is of Mr. Singhania. He can directly ask for bankruptcy if the creditors are backing him.
Correct.
So do I need to make any application?
Even in some cases, even CIRP has not been ordered. Direct liquidation has been ordered in one or two very exceptional cases. So similar kind of thing. Application नहीं करना sir, अब तो आपको report लगानी है. Seek directions, appropriate directions from the court. Just put them all the facts and events which are there. Yes.
Next question is again from Mr. Hemant Mehta. What will be the fate of the legal heir in case of PG bankruptcy when the PG has died during the process?
Very simple. I think that has been clarified in the law itself. There is a specific section, I don't remember the number of section, which clearly says if the bankrupt dies after the process has been started, the bankruptcy proceedings will continue. Because what happens is, that's why I said we need succession laws. What happens, sir, friend, one of the person dies, then the estate of that, all the property belongs to the estate. Now, till the time it is distributed to the legal heirs. So it may take for 6 months, it may take 1 year, we don't know. So the estate becomes liable for everything. And in the estate, there could be an executor, there could be legal heirs. Naturally, we substitute legal heirs in that case. So legal heirs can be proceeded against in the such cases. There is a specific section, I think it is 154, if I'm not wrong, but you can see the
169.
138.
no, 138 नहीं होगा मैडम,
169 है sir, 169.
169, 138 तो discharge का है. Okay.
If a bankrupt dies, the bankruptcy proceeding shall continue as if he were alive.
As he were alive. But now, you see, I would extend this question backwards, which I don't want to answer right now because it will be a very long answer. What happens when the insolvent dies? What happens when the insolvent plan has been approved? He dies after that. There can be n number of situations. So I've dealt with in number of seminars, 6-7 situations, right? So we'll tackle it someday. We'll have a great discussion.
Yes, yes. We will have last 3 questions now. One by Mr. Shankaran Rajgopalan. Sale by the PG during interim moratorium. The NCLT refused to take on record the supplementary report of the IRP informing AA about such sale of assets of the PG during interim moratorium, observing that the application by the creditor is not admitted and as such it is premature. There is no specific bar, but is it not the duty of the IRP to approach AA?
Okay. Friends, this is something which probably I believe Nipun has already covered. The difference between the interim moratorium and the final moratorium 96 and 100 has to be seen. If you look at, read it very closely, 100 clearly says that the debtor shall not transfer, alienate, encumber, or dispose of any of the assets or beneficial interest therein once he has been declared as insolvent. Once the 100 order under section 100 is passed. But that line is missing in 96. So probably NCLT has taken that stricter view. Right now, the question is whether they are right or wrong or whether they should have considered or not. Well, they can, but because at the end of the day, it is also causing prejudice to the creditors and all. And you can always ask for some interim orders and something. But if they are not willing, well, if your creditors are supporting you, maybe you can approach NCLAT and try your luck. Nipun, what do you advise on?
I would add something here, sir. Now with the new amendment law, even 96 will not apply because 96(4) is being introduced, wherein they say that in case of PG of a CD, 96 will not apply. So what will happen in such case? So we will leave it at that.
I'll just add something to this.
Yes.
What my understanding is of interim moratorium and final moratorium, that the law specifically has not included that particular line. Why? Because they say that you are giving a repayment plan. And if you see the contents of the repayment plan, they say you can sell the assets and bring out money and bail you out. So I wanted to touch that particular point, that if you read the language of discharge under insolvency process and the discharge under bankruptcy process, it is different. Difference in the sense that in the insolvency process, the PG is getting discharged after the repayment plan is implemented, qua the debts which are included. Suppose there is some debt which is outside, it is not getting waived or completed in the insolvency process. But if you talk about bankruptcy, it is in rem all the debts, whether they have been filed, not filed, included, not included, everything is getting discharged. So I've always advised that it is better to go under bankruptcy if you do not know how much liability you actually have, because something might be there which have not come on the surface. Tomorrow one repayment plan is given and another creditor after the implementation may again come, and there is no bar. If you read the law, there is no bar. A PG can be insolvent again and again and again. The bar is only when the process is there. If there is a one process, you cannot trigger second process. That's my view.
Right. I think Mr. Udaraj.
Yes, we have covered all the questions now.
Just a sec, sir. Sunil Kumar Kedia ji is raising a lot of legal here and other issues which are very relevant. What I request all of my friends is, I believe everyone is an IPNet member. Now, if you are an IPNet member, go to your dashboard. You can become a member of a study group. We have created a individual insolvency and bankruptcy study group also. And we will invite Nipun also to be a part of it. And we are going to hold some meetings. So we can discuss, that is an informal, that's not a webinar. We just take questions, answers, and we have a discussion, debate, anyone can answer. So I think that's a very fantastic situation which we have created. So I'll request everyone to be a part of it. And if you are not able to do that, you can send a message to Mr. Patwardhan, Namrata, or me. We will share the link of that particular group with you. So become a part of that. I think we will have a discussion. We always have one meeting every month, typically on these issues. So the problems being faced by the our members. So I think please do that. Okay. Sorry, sir.
Yes, yes. And that is fine. Thank you. Back to you, Namrata, for the concluding portion of this webinar today.
Thank you so much. Thank you, Udara sir, for being the moderator and heading this thing. Thank you, Ashish sir, Nipun sir, for removing your time and for this special, of course, personal insolvency and bankruptcy being one of the soft topics we all really like. And now I would like to invite Gauri to give the vote of thanks. The webinar for next week will be announced in due course. Gauri?
Yes, I'm audible, I think.
Yes.
Yes. Okay. First of all, good evening to everyone. And I am privileged to extend the vote of thanks today. I would like to express my sincere gratitude to IPNet for providing me with this opportunity. Today's event is much more than a webinar. It felt like something very significant and a movement that will shape our professional community in the years ahead. First and foremost, I will extend my thanks to the IPNet President Ashish Makhija sir for his keynote address and also to the speaker of today's session along with Makhija sir is Dr. Nipun Singhvi and I for all their words to think bigger and strive for the excellence. And I'm also thankful to them for gracing us with their time and wisdom. Further to that, I would also like to thank our president, Mr. Makhija sir. Sir, your relentless dedication and visionary leadership continue to make IPNet a platform of unparalleled importance. Your address today reaffirmed that we are on the right track under your stewardship. Your guidance gives us the confidence to reach new heights, and for that, we are truly grateful. Again, I am thankful for the sincere efforts by the transition and the technical support team. Their work behind the scene ensure that everything runs smoothly. Their hard work is the foundation for the successful events like this one. Thank you for your unwavering support and flawless execution. And finally, to everyone who has participated, your presence, enthusiasm, and active engagement have made this event a truly remarkable. Together, we are building a community that will not only foster professional growth, but also drive the innovation and collaboration in this field across India. So, thank you all of you who have contributed, participated, and supported this remarkable initiative. Thank you.